If they never showed that version of the indictment to them, to me, that's a substantive problem. It's not just a paperwork issue, especially considering that suspicious inconsistency with the first one saying, oh, actually, we no-billed the whole thing. Now DOJ is trying to clean this up. So they do an additional filing to the court where they want to claim that, oh, we are correcting the record for the court. And actually, that second indictment, the cleaned up document, really was presented to the grand jury and it really was voted upon. So take a look at what they submitted. They style this correction and they say, quote, statements suggesting an issue with the grand jury process. How mysterious, these statements. Gosh, who made those statements? It makes it sound like somebody is trying to confuse the judge. Who made the statements? They did. DOJ made the statements. The Assistant U.S. Attorney Lindsay Halligan both testified to that fact, that the second indictment was not presented to a full grand jury and voted upon, and the Assistant U.S. Attorney also testified to that fact, saying that was his understanding. Okay. They also say that their correction, quote, conclusively refutes that claim. Whose claim is that? Again, this mysterious notion they're refuting something. It's their own claim. They're the ones that said that happened. So now, instead of saying we're correcting, we were mistaken, they try to make it sound like there's somebody they're going against when they're the ones they're going against. You know, it's a well-used technique in debate and in legal arguments to have a straw man, but usually the straw man isn't yourself. So what's the conclusive proof they want to give of this? They use some excerpts from the transcript of the day when Halligan showed up with the grand jury foreperson and these two conflicting indictments. Now, put up that little excerpt. So the foreperson does seem to be saying they voted on the clean version with counts 2 and 3. The next excerpt, the foreperson said, 3 counts should really be 1 count. Oops, there ended up being 2 counts. Like, okay, that's again a problem, right? There wasn't 1 count in the final version. There were 2 counts. And the foreperson refers to it being put in a package. You mean a package like the indictment? The foreperson's not using the right terminology. They're not a lawyer. They're a layperson. So it's possible that the foreperson was pretty stressed out given this confusion being questioned by the judge directly and basically misspoke. What they meant to say is that we definitely voted to indict on counts 2 and 3. And this cleaned up document reflects that. That's a lot of explanation for this kind of cryptic remark and for a remark that shouldn't have to be made at all because the indictment needs to simply speak for itself. So really, what does this new transcript excerpt show? It's DOJ's attempt to clarify its own position, meaning reverse its own position, while pretending that they're refuting somebody's claim when they're actually refuting their own claim. They're contradicting themselves.